Okay, welcome everybody to this Human Rights Seminar organized by the Center for Comparative and Public Law and also the Human Rights Hub at Hong Kong U. I'm very pleased to introduce Dr. Jen Hendry, who we've been lucky to have here as a visiting fellow with the center this semester. Her usual day job, I guess, is as an associate professor and also of law and social justice, and also the director of the Center for Law and Social Justice at the University of Leeds. She has a very broad range of research interests. In fact, she was just here last September presenting with Alex Green on the moral reading of legal pluralism, and today on a somewhat different topic, although perhaps related.
There's overlap.
There's overlap, okay. She'll be speaking to us about the rights of Indigenous people. So without further ado, please join me in welcoming Dr. Hendry.
Yes, many thanks. Yeah, I've been here all semester and it's been lovely, although the weather's been patchy. I was promised sunshine. Come to the subtropics, says Alex. It's beautiful and sunny and lovely, and it's been like hilariously rainy since I got here. No, it's been lovely, and it's been a real pleasure and a privilege to be here, so thank you very much. Just to flag up that, in the interest of fairness to my co-author, that this is work that is co-authored. It's myself and Melissa Tatum from the University of Arizona in Tucson in the US. And we've actually been co-authoring together for quite some time now, since 2014, but more solidly from 2015 onwards. So I've got a selection of the stuff we've done there. And this work, this research, this kind of musings, are drawn from what we hope will become the monograph, Spaces of Indigenous Justice. So this is, in essence, an attempt to provide a bit of a framework for some of the ideas we're articulating through this monograph. So, if that isn't entirely obvious so far, this is very much a work in progress. So it's work that we've been doing on and off by virtue of a hilarious Leeds and now Hong Kong, Tucson time difference and separation. So this has been a little bit on the back burner, and we're coming back to it this summer to revisit a couple of the ideas. So in the sense of work in progress, feedback would be very much appreciated, and interrogations, keep them kind, if at all possible, please. So I don't know how much anybody knows about the United Nations Declaration on the Rights of Indigenous People. So it's over 10 years old now. Originally, when we started looking into it, the intention was to write a 10th anniversary sort of state of play. This is a sort of assessment document of where we've got to with UNDRIP, which is possibly the worst acronym ever. But just as a general overview, this is a culmination of decades, and I say here 2 decades, but officially 2 decades of effort, but really much, much longer. And it really does form a comprehensive statement in terms of the rights of Indigenous peoples, and it gives unprecedented prominence to this idea of collective rights. So the UN website itself states that this was intended as a commitment on the part of the international community to the protection of individual and collective rights of Indigenous people. And the overall aim of the research we're undertaking is really to provide an analysis of practical and procedural issues connected to the assertion, recognition and implementation of collective rights. So there's quite a few moving parts in this sense. It's one of the reasons that it's not going to be a standalone article. It's envisaged as being an integral component of the book. So I actually brought a printout of UNDRIP if anyone wants to have a look at it, so I can pass that over. As I said, I wasn't sure the extent to which anyone would be familiar with it. So I want to cover a couple of these specific points that I outline, and also flagging up what we identify as the main difficulties, problems, issues, stumbling blocks with the exercise or reliance upon collective rights. So the first thing to do is to provide a definition, and the one that we're using is Peter Jones's now reasonably old definition, that a right is only a group right, the term we're using, collective right, if it's borne by the group qua the group. So what distinguishes this right as a group right is its subject as opposed to its object, who it is that holds the rights as opposed to what the right is to. And in this sense, the subject is determinative, not the content. And one of the questions that I got in an earlier presentation is like, well, how do you distinguish this from a general right to education or peace or civil order or something? Arguments coming through, arguably, ideas of the commons. We distinguish it in the sense that these could be categorised as third generation solidarity rights as opposed to rights held by the group, qua the group, so as the subject being the collective. And I mentioned the consultation that UNDRIP utilised, and I kind of just really wanted to flag up a couple of things before progressing. That these are actually two Indigenous scholars. One is Mi'kmaq, Marie-Baptiste Mi'kmaq from Ontario, I think, but certainly Canada, and James Youngblood Henderson is from the Bear Clan of the Chickasaw Nation in the US in Oklahoma. And I think one of the things that is really interesting in this regard is the juxtaposition with a very Eurocentric framing. So this consultation was not without its problems, was not without its difficulties. There was a sense that this was quite a wrench, that it was a challenging thing to partake of, and one that demanded a certain degree of good faith on the part of all participants. As I say, UNDRIP was the culmination of over 20 years, well over 20 years of work, starting with a 1985 working group. It had a first draft in 1993 that was subject to review from 1995 onwards, and this really involved the participation of over 100 Indigenous groups on an annual basis. And I mention this because the involvement of these groups was integral in terms of these collective rights being articulated within the document. And what we've identified is a very loose taxonomy, arguably, of rights here. So straightforward individual rights that we're all familiar with, individual rights held by virtue of membership of a collective, and rights guaranteed to Indigenous peoples as a result of their status as Indigenous peoples, so as a result of the collective. And the majority of these enumerated collective rights are protections for cultural, religious and political distinctiveness and autonomy of Indigenous and tribal people in groups. And as I say in the slide, our focus is on the third category. So of the 40 rights, 35 are explicitly collective, or we've identified them as being explicitly collective. So just a little bit of clarity about these taxonomies. Individual rights, as I say, fairly easily recognisable. This is just one example drawn from Article 7, Section 1. Indigenous individuals have the rights to life, physical, mental integrity, liberty, and security of person. Juxtaposed with a collective right in Section 2, which actually uses the term collective right to live in freedom, peace and security as distinct peoples, etc. And we're differentiating this from rights held by Indigenous peoples that are both individual and collective. So these are a little complicated in the sense that there's no clear distinction in terms of who is entitled to exercise a right and under what circumstances. And when we were looking at this originally, one of the things that we thought was like, well, how can collective rights be defined and understood? And what we really came up with was, well, we have to look at how they're exercised in order to get some more information about this. One of the things we noticed is that collective rights often do have an individual rights analogue, and arguably this is something that's caused a lot of problems in their exercise and implementation. So just to flip back, you can see that this is a very clear Indigenous peoples and individuals, Indigenous peoples and individuals. So the repetition of this through the construction of the right has led, oftentimes, we argue, to a regression isn't the correct term, but a default almost to the individual analogue of what we would say is a broader collective right, or a right that can be claimed by the collective. And Les Green has written about this. He's written about this, this idea of the right held by the group and distinguishing this from a simple aggregation of rights held by individuals. So if the individuals comprising the group are rights holders as discrete individuals, then an accumulation of those individual rights does not equate to a collective right. Collective rights, as we're arguing, and again to use the Peter Jones definition, that what distinguishes a right as a group right is its subject and not its content. Collective rights must amount to more than simply an aggregate of rights held by individuals. Again, to use Les Green, I say again, I haven't mentioned him yet, I use him a lot in the paper. If the Mohawk Nation has the collective right to self-determination, then it has to amount to more than the sets of rights of individual Mohawks to associate freely, to organise for autonomous political institutions, and so on. We could easily regress to individual rights in that situation, and the collective right has to be conceptually distinct. It has to be understood as different from this. Les Green also points out that there's a power to the language of rights, so a possible inquiry here is why rely upon rights, something so innately individualistic in its conceptualization, why rely upon that for the realization of collective goals? And I think this is an interesting query. Why are rights the vehicle? What makes them a suitable vehicle for this endeavour? And Green actually answers this question as well. He says, well, the language of rights has its own power. There's a status and privilege that comes with the utilisation of the language of rights. But not just that, there's a statement, a reciprocal statement coming from those who claim a right, that they are part of that political community in the first instance, and also that they're utilising a common language of rights. So I think there's an interesting reciprocity in that sense also. So really by way of scene setting, one of the other papers we wrote, a very early law review paper, was on an argument about differing Indigenous conceptions of rights. And one of the things that we identified in this work was really a reliance within rights discourse, Western liberal rights discourse, on what is a Western conception of society. So arguably a very social contractarian basis. And in this sense, what we recognised is really a sphere of autonomy surrounding the individual, that the social dimension of the common arguably only extends so far as is necessary to underpin social order. So that Hobbesian idea of a sphere of autonomy remaining to a certain extent inviolable. And I think this is something that I'd quite like some input on. One of the things we were thinking about was juxtaposing this individualist Western basis of thought with a more communitarian, arguably continental conception. So arguably Heidegger's law of the possible, Arendt's right to have rights, a kind of feudalistic patron-client argument, and then perhaps more contemporary arguably contemporary, nearly 20 years old now, conceptions of the commons coming through Hart and Negri, for example. So this is arguably a tangent that could be considered, and I haven't done that research yet, but it's something arguably to think about. The work that we have done so far is that Western liberal thought has been influential, just uncontrovertibly influential in the construction and the mediation of the relationship between the individual and the state. And this is often characterised by antagonism and adversarialism. I think Waldron uses the term, the kind of muscular adversarialism of individual rights. And we note the dominance of this Western conception, but we also note this as a contingent selection, as something that's been chosen as one path of many. So arguably these worldviews can be different, but they're not deep-seated ideological differences. They're contingent selections. So I'd just like to juxtapose a liberal Western view with a more communitarian, to use a loaded term, Indigenous view. And at this point, I think it's important to use a disclaimer, and if you're familiar with any work on Indigenous justice, then this will be a familiar one, that tribes and communities and people identifying as Indigenous will often have very different, frequently have very different conceptions of law, will often have very different values, differing from tribe to tribe, people to people. There's no intention here to assert these as pan-Indigenous claims. There's no intention of collapsing any of these rich jurisprudential traditions into a single model. So just, I'm conscious of drawing abstract conclusions about things that are very difficult to abstract, so just to flag that up at this stage. So this is the argument that we take, that the inherent individualism of a liberal approach sits at odds with Indigenous conceptions that take their starting point to be, as Clinton outlines, the family and the tribe, as opposed to the unit of the individual. So there's a shift, a reasonably subtle shift, but one that has enormous repercussions in terms of broader conceptualizations moving forward. And as I say, we think that this may be something that is simply not intuitive to Westerners while being wholly intuitive to non-Westerners. A cumulative construction of identity and a familiarity with collective decision-making that doesn't just take place in a collective but has a temporal aspect that considers what has gone before and generations to come. So we think that there's this perhaps conceptual disconnect at the foundation that has led to different understandings. As rights discourse has followed a very particular route, one determined and driven by Western liberal ideology that channels it into a particular form. And the argument is that this particular form has had the effect of undermining the potential of collective rights that have been, as I say, in place since September 2007 and haven't really been as exciting or groundbreaking or as influential as we would have liked, certainly would have hoped. Because we think that this is quite a radical, or has quite radical potential, and the way that we understand and recognise and uphold rights claims could be very different if this collective rights idea has a greater chance to breathe. And originally this was, UNDRIP was held as being a very exciting development. And Megan Davis, who's been involved as, I think was chair of the Permanent Forum, the UN Permanent Forum for a little while, she said this is a victory, straight up a victory for Indigenous peoples who have now an international instrument imbued with an ongoing philosophical questioning of, effectively, Westphalian sovereignty and state centrism. But I think these are the these are the problems. And again, these are a little bit essentialised, for want of a better term, but we think that there are practical difficulties and procedural difficulties that underpin this lack of use, arguably, in terms of collective rights. One problem is straight up the individual analogue, that a lack of familiarity with the idea of collective rights means that they're often elided with the individual rights, and they're effectively rolled back into being an aggregate of individual rights. A second one, what we've outlined here is as practical as the lack of an agent, is one of voice. So who speaks on behalf of the collective? And this is something that I'll talk about a little bit later on, but who is empowered to speak on behalf of the community? In the situations where there are government-to-government mechanisms in place, then this is far more obvious. In the situation where there are no mechanisms, then that becomes very difficult. There's been some work done in the US, for example, in terms of membership. It's a very fraught issue in the US, membership of tribes. If you're familiar with the Australian example, there's blood quantum questions as well. So oftentimes simple membership of your Indigenous group is something that can be contested. And then you have complications like urban Indigenous, grassroots Indigenous, and who's speaking on behalf of these different groups becomes something that can be quite contested. So that's one instance. And another one is procedure, just a pure and simple lack of mechanisms, dedicated mechanisms certainly, but a lack of mechanisms to allow for this voice to be spoken and heard within notably national, but certainly also international arenas and fora. And I'm conscious that this is all a little abstract, so I wanted to use a case that I'm familiar with from other work, and a case that is not an international human rights case, and is also not one that would have been subject to UNDRIP because it came earlier. It's just one that I think raises an issue that arguably could have been addressed through UNDRIP collective rights or rights enumerated in the declaration. So I don't know if anyone is familiar with this case. It's a very interesting case. It concerns the border between Nigeria and Cameroon in West Africa, the Bakassi Peninsula, which was contested. I'd like to say it was contested because people really wanted to lay claim to their Indigenous peoples so that they could be supportive and encouraging and maintain their political community. It wasn't. They found petrol and gas. So the contestation really arose through wanting to access oil-rich petrol, gas-rich and petrol area. And this border dispute arose as a direct result of ambiguities surrounding the quotation here, the indiscriminate and haphazard fixing of the African boundaries by Europeans. And what had really happened was a line had been drawn down the Bakassi Peninsula, and it wasn't clear which side of the line it should go on. So this case went to the ICJ, and Cameroon claimed that the Bakassi Peninsula was theirs according to the 1913 Anglo-German treaty. Interestingly, Anglo-German, Germany lost this territory to France in the Treaty of Versailles, so just an additional complication. While Nigeria argued that Britain actually had no title to cede the Bakassi Peninsula to Germany because the title was held by the kings and chiefs of Old Calabar. And there were various arguments led, but ultimately what the court did was confirm the British administration by indirect rule and voted 13-3 that title lay with Cameroon. So on the face of it, quite a straightforward decision. What doesn't feature in any way in this decision, understandably, because of course the jurisdiction of the court doesn't doesn't include non-states. The ICJ analysis, of course, focused on successor interest under the various treaties, looking at state parties. Again, you see a state-centric dimension come in, and there was absolutely no attention paid, no discussion within the case about the tribe that lived there. So the ethnic people of the Bakassi Peninsula had no standing in this case, no collective voice and no platform to make a decision, even though this result impacted directly upon them. So I've pulled out some of the most important dimensions of this case here. A very clear disjunction between international law and international human rights law. An overtly state-centric approach, which we can of course perhaps expect in international law and public international law specifically, and a jurisdictional blind spot in this sense. And I've written elsewhere on this in relation to legal pluralism, but I think it's an interesting hypothetical in this situation, because this is what the indigenous people were left with. And this is a quote from Reuben Abati, who ended up being a spokesperson for the Nigerian president, but in 2009 when he made this point was effectively a public intellectual, a journalist in Nigeria. And these were the options: take Cameroonian nationality, so become nationally Cameroonian, or retain Nigerian nationality and be a refugee. So that was your, become foreigners in your ancestral homeland. And I think this quote is a really sad one. It's really evocative in that these people have been entirely forgotten, they've been marginalised, they've been excluded by this process. And even now there are huge problems in the Bakassi Peninsula in terms of people being able to live traditional lifestyle and adjust to their new situation. Would this case have been decided differently had UNDRIP been in play? Well, arguably not, because the situation in terms of what the ICJ can do would be much of a muchness. Would there have been greater potential for legal action within either Nigeria or Cameroon? Arguably, yes. So I think that this is interesting, and you can see that there's a degree of potential that UNDRIP would offer in this situation, but this is the kind of problem that I think that it has utility in fixing. And this just isn't the case on the international stage. I think it's also something that should be considered at the national stage, because it's arguably at the national stage that would have that there would have been more purchase, there would have been more influence, more potential accommodation in terms of these bigger questions. And I don't know if anyone has been following the Australian election just earlier this week, but one of the things that's been thrown up in the air has been what is going to happen in terms of Australia's treatment and engagement with its Aboriginal and Torres Strait Islander people. And I mentioned this because just slightly conscious of time, because the Uluru Statement from the Heart is something that I think really speaks very specifically to the issues that that we identify in this conundrum. So the Uluru Statement from the Heart, again, if anyone isn't familiar with it, was a statement signed by many Indigenous representatives at Uluru. Actually, it ended up being somewhat controversial because the people signing it didn't actually ask for permission to use Uluru as the term, and they didn't ask permission from the Anangu people who hold it as a sacred site. So there's something quite, I hesitate to say entertaining, but somewhat ironic about this this statement having erroneously utilised Uluru as a term without asking for permission from traditional owners. However, this is a segment from the statement. I couldn't include all of it, but one of the difficulties we identify is, as I say, this procedural one and this lack of a mechanism. And the other one is the practical lack of a voice. In Australia, a lot of tribal and Indigenous rights justice claims and articulation to come through public intellectuals. So people like Megan Davis, who I've quoted, who's chaired the Permanent Forum for a while, people like Noel Pearson, and there are questions over the legitimacy of these individuals and the standing of these individuals to speak for the whole group and to speak for, so for example, people of Aboriginal heritage speaking for Torres Strait Islanders and vice versa. And this isn't a small problem. This is something that's led to real divisions within the community, to questions over solidarity, and it's a problem. So in the event that there is government-to-government relationships, it's a far clearer picture. Tribes in the USA perhaps being the obvious one, regarded as governmental entities, and sovereign governments and unceded sovereignty. A collective tribal voice is far more easily recognised because that voice will be legitimate according to internal tribal norms. It's far more difficult to identify when such mechanisms, when such internal mechanisms don't exist, and also when there's no clear membership criteria. Similarly, when there's no reservation or territorial underpinning for the groups. So again, I mentioned urban and grassroots separations of the groups. So what if none such voice exists? What if we can't identify the contours of a collective, and what if we can't identify who has standing to speak as the voice, as the legitimate voice of that collective? And I use the Uluru Statement as an example of something that purported to do that really did establish itself. And you can see some of the language here. This is the torment of our powerlessness. We seek constitutional reform to empower our people and take a rightful place in the country. We call for the establishment of a First Nations voice enshrined in the Constitution. And the idea was, and may still be, but it's very much on the back burner at the moment while things happen in Australia. The idea was that this would establish a constitutionally recognised body for Aboriginal and Torres Strait Islander communities. So just by way of conclusion, these are the challenges that we identify in terms of collective rights. So to reiterate, we think they have real radical potential. We think that UNDRIP was bold as an international statement of intent. It really did operate in good faith, attempted to operate in good faith with the degree of consultation, the quantity of Indigenous groups involved. But there are huge difficulties in implementation, and we argue that these effectively come from conceptual foundations and difficulties with practicalities, procedural practicalities, most obviously. So these are the challenges. It can be difficult to communicate the intent of a community if there's no obvious agent to use the voice. It can be difficult to identify the contours of the community, who is included and on what grounds, who is entitled to speak for that community, and what mechanisms are there to allow for the implementation specifically of a collective right as opposed to simple aggregates of individual rights, or indeed an individual right in and of itself. And that, I think, is where I'm going.
Great. Thank you very much. We do have plenty of time for questions and comments. Jeff?
So a couple thoughts on this, and some of these things you touched on. So why with this difficulty in rights and that you lay out, why a language of rights and not a language of sovereignty, right? As an American, right? That's like the default way in which it's hugely problematic, but in a lot of ways, but that sidesteps these issues, right? You fight for a circumscribed sort of sphere of sovereignty, and then all these other types of questions are sort of put to the side because you just don't, get to have, access. So it's sort of nullifying other people's rights as opposed in an affirmative way rather than establishing ones that you have to, litigate in some other context. So that's one thought. You mentioned this thing about membership, and this is one of these hot issues, as you were saying, like in the U.S. because of casino money.
Yeah.
People are basically kicking people out of tribes, and this was one of actually the things when Elizabeth Warren went through this debacle of claiming it wasn't just
that was a misstep.
It wasn't just the discursive political misstep, but it's the fact that many tribal authorities resist DNA tests because they don't want an objective measure, because they want to retain power over these things. And so this has raised the claim of, even in the context of that, does the existence of collective rights obliterate your liberal individual rights in these other contexts? Because people say, like given how things are structured, you have no redress. No matter how horrible the decision is made, no matter how long your family's been there, that's part of how the sovereignty systems works, right? We don't look into the internal decision-making processes. So is there any ground then to look for individuals to make claims against internal processes, within these collective spheres? And I think that raises the thing that people have often, the answer is no, because it's so easy to go to the outside system as an individual and start making claims for all the reasons that you note here, right? And there's very little defense against that. So the last two are a little bit more conceptual, and one of these things is, from an anthropological, perspective, historically, everyone was, I guess, an indigenous group at some point, depending on how you define it. So does it help us understand if we could think about how people move in and out of this category? I mean, at some point, people in different parts of the even Western world made claims that were parallel to this about sovereignty in smaller groups. And then eventually they became assimilated into the nation, and they no longer conceptualized themselves as indigenous. Part of how could we draw that line, right? When a group goes from being able to make these types of claims to not being able to make it because they're not distinguishable from the state. And then I guess in the East Asian or Islamic or other sort of context, there's lots of states that make these types of communitarian claims, and they, that are sort of non-Western, sort of the Asian values debates and other things. China is very happy to make these types of claims. And then they're like, yeah, this is the part of the problem with these groups is they don't understand that they are part of a different collective than they imagine, right? And like the Uyghurs, they need to be sort of reprocessed into the proper collective, right? So if you have an actor who you're looking to restrain who speaks in the language of communitarianism, how does this provide a sword against that, and does it sort of facilitate, further deconstruction, because it's just the language is not as antagonistic as it is in the liberal context?
Thank you. Shall I? Why rights and not sovereignty? Yeah. I think arguably because, in terms of why rights and not sovereignty, I think the US is. We don't say this much about the US, but the US is actually not the worst in terms of its engagement with its indigenous peoples, and that is hard to believe because it's really quite bad. But it's nowhere near the worst. Australia's really not doing well at all, and really never has done. I think the language of sovereignty is far, far harder to use in circumstances where genocide has been far more successful than in the US, and in the US it was pretty successful. So I think the language of rights and that power, emancipatory power of rights, is preferable. I haven't thought about it explicitly, but I think it's preferable, and I think arguably sovereign claims will be a lot harder for smaller groups, but that's certainly something to think about. In terms of don't look at internal processes, there's interesting cases come up in the US context about this, and probably the one that springs most readily to mind is that Martinez case against the Santa Clara Pueblo. And it was a non-discrimination case. It was effectively the tribal provision meant that if you were the child of a male tribal member, then you had membership. You had membership of the tribe. Whether or not you were born on Indian country or not, it was just pure and simple. If that's your father, then you're a member. And it was not the same if you were descended from a female tribal member. You did not have tribal membership. So this was brought to court, and the decision in the US system was that this was discriminatory. And then there was quite an uproar about this, and it was interesting because I know that Catherine McKinnon has written on this from a feminist perspective, and she was like, this is a really positive decision, and a lot of the Indigenous women at the same conference were like, no, it's not a positive decision because it flies in the face of tribal sovereignty, and that's the most important thing. So I think there's a very real tension between this rights sovereignty argument, and in the US the debate is really quite clear that tribal sovereignty comes first. And I'm not sure, I think that probably need more empirical work, and the extent to which empirical work is likely to show that up to any consistent way. I don't suspect that is going to be the case everywhere. I speculate, honestly, but I don't suspect that's going to be the case everywhere. In terms of an obliteration of individual rights, that's the tension, right? So you arguably, we were talking about this in terms of our paper recently, so I'm conscious of Alex nodding there. If you recognise tribal jurisdiction and tribal sovereignty, then there's a certain extent where it has to be, you have to take it seriously. I think that only holds so far as there is respect for certain universal values, and I think, again, that comes back to the point that if you're using the language of rights, then you are effectively partaking within a political community that's bigger and broader than your collective. So being part of that bigger system requires a minimum standard, and I think that's the same answer I would give to arguments about like female circumcision and arguably male circumcision as well. So yeah, I think I have to think a little bit more about that in specific, but that's probably where I go. I still have a lot to deal with. The anthropological perspective. I think this is really interesting because in the African context, there's a lot of work being done. Chris Thornhill in Manchester, Manchester division of. He's been doing quite a lot of work looking specifically at Kenya, and his work is really playing with this idea of ethnicity as opposed to indigeneity, and he's recognising this as fluid categories. I mean, the UN doesn't even purport, it's quite brave in some respects, but it's definitely not brave in terms of drawing lines where cut-offs are for indigenous or not indigenous, and like that we don't have a working definition really. And arguably there's questions over whether mechanisms in place to help minority communities really work in situations where the indigenous group is not the minority. So Bolivia, for example, where they're not the majority are in fact in power and government and have been for some time, and there's arguments that the non-indigenous minority are in fact the disadvantaged in that situation. But I think James Anaya's work's really interesting in this regard, because what he has argued that in terms of self-determination, that it doesn't need to be self-determination in the sense of a nation state. They don't have to replicate state mechanisms and territory and structure and stuff like that. There has to be sufficient recognition of distinctiveness, but this doesn't have to have the trappings of statehood as well. And I think arguably that in-between stage, autonomous community, devolved polity, something like that, even the reservations would arguably tick sufficient of a box, I think, to constitute self-determination in that sense. Is that okay? Okay. It's a lot. There's a lot there.
Alex, did you go ahead?
Thanks. Yeah, I just wanted to sort of add to this because Jed talked about many of the things that I would have asked about, but I think that the contrast that's been set up is not as stark as that discussion suggests, because in international law, sovereignty is not as strong a concept as political rhetoric makes it sound. In fact, most doctrinal international lawyers would simply understand sovereignty to be the collection of rights and powers that attach to a state by virtue of its statehood, or at least the capacity to hold a certain collection of rights and powers. And so the distinction between having a collective right and being sovereign is actually not very strong at all, because the paradigm case of the collective right holder is the state. So these two perspectives probably get closer together than that discussion suggested. And I mean, I guess then the contribution to the paper would be something like this: the line in between where arguments about sovereignty stop and arguments about human rights begin is probably at that kind of institutional tipping point that you're contemplating, where it no longer makes sense to talk about these communities as effectively the states that the international legal system forgot or ignored or sublimated, right? Because there's no longer a sufficient institutional structure there to behave in any way like a state. And in that respect, I think another judgment that might be worth looking at is the Western Sahara opinion, because so in my view, the ICJ got its interpretation of the statehood criteria in Western Sahara wrong, insofar as it was looking at territorial control, because it effectively said that the Bedouin exercised some kind of occupancy of the territory, but not sufficient to establish title on the part of states, because their nomadic lifestyle, etc., etc. And I think that this kind of, and it's not state-centric, it's post-Renaissance European-centric. And those two things get confused, and I think you could easily have a more capacious understanding of, so for instance, the territorial criterion that would bring together tribal sovereignty claims, even when they're made on the basis of nomadic peoples or more fractured or atypical political arrangements, in such a way that it would start speaking in a more recognizable state-based sense to these collective rights. And again, the analogy with the state is helpful for another reason, which is that pretty much nobody thinks that because states have collective rights as a matter of public international law, that individual rights are not opposable against them. In fact, the starting point is because of the power of states, partly constituted by international law, it is important that human rights are opposable against them. And I see no reason why, in a modified form, the same argument shouldn't work in respect of indigenous communities. And I guess the final thing is actually on Jed's final point about indigeneity, and I just wanted to ask you what you thought about David's criterion for indigeneity. So we discussed this over dinner with him briefly, but he said that what might unify a group, this is David Dysenhouse, sorry, what might unify a group as an indigenous group is a combination of having been a historical victim of colonialism during the sort of 18th and 19th centuries, plus a particular relationship of vulnerability insofar as that community is tied to a particular area of land or a particular way of life. And I'm wondering whether that might be a way of, if not drawing a fine line, because I'm not sure that's ever possible in cases like this because of the particularity of at least giving a kind of conceptual core. Because I've been thinking about that more and more, and I think that's quite an attractive.
Yeah, I mean, so I rather like the criteria. I'm always conscious, I'm hyper-conscious of being British. I very rarely self-identify as British incidentally, but I'm hyper-conscious of being British when I'm like, here's my criteria for indigeneity. So I'm really very, very self-aware in that sense, so I'd rather not, in all honesty, not touch it. But one of my friends, Mark McMillan, who's Aboriginal. He said that there's a 3-part construction for tribal membership for him. And I always thought his was interesting, and he says that there has to be an ethnic dimension that doesn't stretch necessarily to blood quantum. He's like, I'm not getting into blood. But there has to be an ethnic dimension, there has to be some form of relationship. You then have to self-identify as either the tribe or as generally Aboriginal, and then you have to be accepted by the tribe. So there's like a 3-part dimension, that there has to be some objective criterion, and he's like, this is sort of in ether, and that's the one that will ultimately prove important, which is I think why it's in the ether. Then it's self-identification and reciprocal identification on the part of the collective that you're claiming to be.
That's very communitarian, isn't it? It's possibly much more strongly than anything else we've discussed so far. So perhaps the tension with individual rights comes back very strongly, if that's what it turns out.
I mean, that's his. I think in terms of an individual claiming membership, recognition, ethnicity. I think David's criteria are great, up to the point that one big group doesn't fit them, and then you have problems. And I think that this kind of, in the past, have been badly treated thing is quite problematic, and also there's difficulties with the connection to land. I think there's Maori tribes that would arguably not really fit very well into that because of mobile, comparable arguably to Bedouin, although in a very different situation. Mobile trajectories, patterns, historical migratory things that I'm very reluctant to categorise. If the UN aren't brave enough to do it, then I don't think I have to, basically.
Could I ask you, do you think there's any scope or possibility that the declaration could become a legally binding instrument? And if it, I mean, it sounds like probably not, but if it were to become a legally binding instrument, do you think that would help to resolve some of the tensions you've identified, or do you think it would actually exacerbate?
That is a good question. I think probably not. I think it's
Probably not becoming.
I think probably not becoming, and I think its declaration, I think its wide-ranging, I think its ambition and its wide-ranging nature goes really hand in hand with the fact that it is a declaration. And I think that there's an aspirational quality to it that would be quite difficult, depressingly quite difficult to effect. In the event that there were to be a more concrete document, I think it would be a hard law document. I think arguably you could pull out certain of the rights and be like, no, this is something that you have to stand by, and I don't think that would be terribly hard to do. I think there are some that would be problematic. I don't know how the self-determination provisions would work. Like explicitly the self-determination provisions would work in terms of PIL practice, which are quite overtly contrary to anything that breaks up nation states. So that sort of like remedial secession would be problematic in that regard. But it would be nice to see a more reliable document, like what we're actually hoping to do, which time and money. Would that we had more time and more money. What we'd really like to do is a wide-ranging empirical study that looks specifically into South and Central America and certain African nations, to see the extent to which UNDRIP provisions are being relied upon in state internal. But it just requires being able to speak Spanish and Portuguese, which I don't do. But yeah, that'd be the work that we'd do if we had the time and money.
Thank you very much. The question about all these rights spinning around, but no talk of where these rights are attached to certain obligations. So if we think of rights as correlative to obligations, where do these attach to? And that may be one way of thinking through the problem of the national or the domestic and the international. Because the danger about both representation, I mean representation is a trap in some ways that you need to watch for, but the problem of self-determination, which is another way of thinking about sovereignty, is that if it remains at the domestic level,